Alan and Elise, thank you so much for coming into my office today. As you know, we've been working together over the last few months to discuss your current financial situation, your long-term financial goals, and to make sure you're on path to reach these goals. Now, before we dive into the details of the plan, I'd first like to say congratulations and really commend you on where you're at right now and all that you've accomplished up until this point. You're both duly employed, working together at ABC Corp in a very successful capacity. And Elise, it's very clear, as Alan's administrative assistant, that your hard work has played a key role in enabling Alan to get to this executive level position. Now, one of the first things I'd like to discuss today is your estate planning. Now, let me first start by reviewing what I think I've heard from you. You mentioned that you currently don't have any estate planning in place. You've never signed a will and you don't have any kind of trust set up. I want to first emphasize that you meet with an estate planning attorney because I'm not an attorney and I do not engage in the practice of law, which therein prevents me from providing any kind of specific legal advice. With that said, though, we can address some general deficiencies within your family situation. By drafting a will, it'll enable you to name the executor of your estate, and they are the person who's responsible for settling out your estate. This would also enable you to name a guardian for your children, specifically Kelsey. In light of how young she is, it's very important for something to be on file specifically containing that information. And while I think we're all in agreement that Sarah is the best option, Sarah's currently named as a contingent beneficiary, but the will ensure she also acts as a guardian. Even though your current estate is under the estate tax threshold, I recommend you consider having your will authorize the creation of a trust. The trust can hold any assets that you leave behind for Kelsey, Jerry, and Chris. The main purpose of this trust is that you can also appoint a trustee. This trustee can manage the assets on behalf of the children and make disbursements to them as authorized by the trust document. The person in the role of the trustee would want to have some financial sophistication. And as I mentioned earlier, I know Sarah, Elisa's sister, is currently a contingent beneficiary in the life insurance and the retirement accounts. And while that establishes her, once we establish her as the official custodian of the children, her primarily responsibility will be due to caring for the children's well-being, and that will be official. But in light of the contentious relationship between Alan and the boys, Jerry Jr. and Chris, we may want to consider separating Sarah's responsibility in caring for the children and the disbursement and management of the state assets. This way you can spare Sarah the financial responsibility of managing the estate. When you meet with an attorney, consider assigning a financial institution as a trustee of the trust so that the financial institution can act as conservatorship. This will enable Sarah to focus on the well-being of the children as their guardian, especially Kelsey, due to her young age, and she won't have to worry about being responsible for deciphering which portion of the estate should be distributed to the boys and which portion should be left for the needs of Kelsey. I'd also suggest to include any medical directives in the will, so that if anything should happen, your physicians should have some instructions on how to proceed. Another item is a durable power of attorney, otherwise known as a healthcare proxy. I suggest, since it's between the both of you being spouses, you can elect for it to be a springing power of attorney. So here's an example of when a document like this would come in handy. Let's say you're in a car accident and the medical staff needs instructions on what kind of care to provide. This document would provide clear instructions on who to turn to in a time like this. The power of attorney is important because, again, due to the dissension between the two boys and Alan, if anything were to happen to Elise, they'd know who to listen to and take instructions from. If since the size of your current assets are so far under the estate tax threshold and the estate planning attorney feels that a trust isn't fully necessary, at least make sure a personal letter of instruction is established. This will provide instructions on how you want things to go after you pass away, such as funeral arrangements, and provide the location of important documents. Now, the probate process is the legal process by which a will is reviewed and determined whether it's valid and authentic. Now, this probate process is generally administrative in acting out the deceased person's will. It often entails long, drawn-out processes and can be made public as well. So wherever possible, you really want to make sure that your existing accounts are set up properly so they don't need to go through the probate process. This is why it will be very important to update the beneficiary information on all retirement accounts. As long as you are one another's beneficiary on one another's respective retirement accounts, this will ensure those assets don't go through probate. We also want to update the beneficiaries of the insurance so that the estate is not the beneficiary, but someone as a member of the family or the trust. And when doing this, it essentially means when you die, the probate process won't need to look at the will to see where the money in the IRA, the 401ks go. This will already have been provided from the beneficiary information on the accounts. Now, in order to avoid the probate process for those accounts that are in your name only, we should really consider retitling them as TOD accounts or POD as transfer on death or payable upon death for those accounts that you wish to keep in singly owned for each respective spouse. Now, this would enable your assets to remain exclusively in your names, but the instructions provided would enable them to transfer without them going through probate. Now, outside of estate planning, I'd like to suggest just a few other items that we do go into more detail in the written financial plan. One is we should really consider establishing an emergency fund, something in a very liquid, maybe FDIC insured account. We should consider maybe establishing a 529 plan either for the boys or for Kelsey, preferably in your home state. That would potentially get us out of, potentially get us a state income tax deduction and would enable tax-free withdrawals of any growth in the account that would go to qualified higher education expenses. I'd also like to establish a formal investment policy statement with you based on the risk tolerances that we've discussed. Consider increasing the life insurance coverage that currently exists and adding a lease to the disability policy as well. Now, while these are my recommendations, if you implement these suggestions as I've laid out in the written financial plan, and we continue to meet on an ongoing basis, there's no reason why we can't potentially increase the probability of your meeting your financial goals long term. Now, I'm happy to answer any questions you may have. Again, I'd like to suggest that we meet again in a couple of months after you've had a chance to sit down with the estate planning attorney so we can follow up and discuss what the next step is with your financial plan. Thank you for taking the time to come in, and I look forward to continue working with you going forward. Thanks.